Welcome. I'm Bob Rubin, and on behalf of my colleagues at the Hamilton Project, welcome to today's forum, which, as you know, is the economics of bail, fines, and fees in the criminal justice system. In 2008, about 2 years after the beginning of the Hamilton Project, we had our first forum on criminal justice reform. We came to the topic because we've been very focused on urban poverty, the poverty that has replicated itself through generations. But then we realized that there was a criminal justice component to this, and a very serious criminal justice component, and that led us to the recognition that the criminal justice system was greatly exacerbating the poverty problems that we were focused on. It also led us to recognize the enormous dysfunction of our criminal justice system, which is excessive, as you all know, in many respects. And the numbers of people incarcerated, about 6 times the average of the developed countries, the sentences that are too long, parole and probation that's too rigid, and very importantly, the inadequate preparation that we give to people in prison for life after prison, and then the support that we give after they have been released. One of the things that struck me at that first Hamilton Project forum was that people, this was 2008, mind you, people had come from all over the country, practitioners, policy analysts, public officials. And when I asked why they had come, they said this is the first opportunity they had had to discuss these subjects with a DC platform. Now, of course, that's changed. There's tremendous focus in Washington, but in that time there wasn't, and this was very early in that process. Also, people said to me, this was the first time they've been involved in a focus on these issues that was from an economic, or through an economic lens, which was very much the focus of the Hamilton Project. We've had several fora on this topic since, and there certainly has been a lot of progress on the one hand, but a vast amount remains to be done. In 2016, I went to San Quentin. I'd been invited to give a TEDx talk. And the experience crystallized for me a comment that one of the people in prison made to me, and I registered and it stayed with me ever since, which is none of us, none of them, but also none of us, should be judged by the worst thing we've ever done. 2 of the people that I met at San Quentin, I've stayed in touch with. They're on parole now, and I've stayed in touch with. I was with lunch with one of them, I guess it was 2-3 weeks ago, and he was telling me how inadequate the preparation had been, both while he was in prison and how inadequate the support was now for re-entering mainstream society and mainstream economy, although he himself was actually doing quite well, an extraordinarily impressive individual. In the context of criminal justice reform, we're going to focus today, as I mentioned a moment ago, on bail, fines, and fees, including in fees restitution. There are, as all of us know, all of you know, enormous inequities in our criminal justice system. And with respect to focusing on bail for the moment, if you're accused and you can afford to post bail, you don't go to jail. If you're accused and you don't have the financial resources to provide bail, you do go to jail. And on any given day, it's been estimated there are about 500,000 people in jail because of an inability to provide bail. And going to jail is not only in itself obviously a very difficult experience, but it has another consequence. Some number of those who go to jail plead guilty even though they're innocent because they get time served or probation. And the problem there is they have a criminal record, and that then adversely affects them as they seek employment subsequent to that experience. The costs to them are obviously enormous, but the costs to our society and our economy are also very great. We're also going to focus on fines and fees, including restitution. These fees and the debt that is incurred follow people from the time they leave prison for the rest of through their lives until they can afford to pay them. And very often for these people, paying off those fees or that debt incurred in the criminal justice system is very difficult. It limits job prospects, and it really undermines their effort to get back into our society. Two people I had lunch, or not lunch, I had lunch with one of them, and then I met with the other. Two people I met and who are now on parole from San Quentin have respectively $8,000 and $20,000 of debt. And for those people in that situation, that's a lot of money. It's been estimated that the cumulative debt incurred through the criminal justice system is somewhere around $124 billion as of the fiscal year 2017. Another topic we'll be looking at today is the use of fees and fines created by the criminal justice system as a budgetary measure, which then distorts the conduct of the criminal justice process. To discuss all of this, we are deeply appreciative of having with us highly experienced and deeply knowledgeable participants in panels and authors of our papers. In keeping with the practices of the Hamilton Project, I won't introduce them at this point. They'll be introduced by our moderators. But let me just say, there's a remarkable group of people, and we are very fortunate, all of us are very fortunate to have them with us. Our first panel will be moderated by Ryan Nunn, the Policy Director of the Hamilton Project and an Economic Studies Fellow at the Brookings Institute. He will be discussing policy options to reform the use of fees, fines, and forfeitures. And then we'll have the case for reforming or eliminating cash bail, moderated by Maya Wiley, a legal analyst for NBC News and MSNBC, and Henry Cohen, Professor of Urban Policy and Management and Senior Vice President for Social Justice at the New School. That's a lot of titles for one person, but we're delighted to have her. Let me say before I conclude that we are very fortunate at the Hamilton Project to have terrific leadership. I've mentioned Ryan already, our policy director, who is deeply thoughtful and knowledgeable, widely respected and outstanding director of the Hamilton Project, Jay Shambo, and our highly effective managing director, Kristen McIntosh. We also have a remarkable staff, and without whose work we could not accomplish any of what we do. And with that, let me turn the panel, or the forum, over to the first panel. Thank you all.
I'm going to regret this decision.
Good morning. I'm Ryan Nunn. I'm the Policy Director for the Hamilton Project. I'll be your moderator for this panel, Policy Options to Reform the Use of Fines, Fees, and Forfeiture. I think we have a really terrific panel. I'm excited to talk to them about all these issues. You can see their full bios in the agenda, but I'll give you a quick title for each of them. So directly to my left, Kristen Clark is President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Next we have Jeremy Travis, who is Executive Vice President of Criminal Justice at Arnold Ventures. Next we have Danielle Allen, who is James Bryant Conant University Professor and Director of the Edmund J. Safra Center for Ethics at Harvard University. Next to her we have Beth Colgan, who is Professor of Law at UCLA and the author of one of the proposals that we'll be discussing today. And then finally we have Michael Mikowski, who is Associate Professor of Economics at Clemson University and the author of a second proposal that we will be discussing today. So I'll just say a few quick words about sort of the scope for this discussion on this panel. I think we're here to talk about fines, fees, and forfeiture, in part because our criminal justice system is making more and more use of them over time. Where once monetary sanctions were really a matter of fines, specifically designed to deter crime and to punish it, now we see a much larger role for fees and forfeiture as well. More than half of people in prison have incurred fees, with smaller fractions subject to fines and restitution in addition. And we see many local jurisdictions raising a lot of revenue from these sanctions. The top 5% actually offset about half of their criminal justice expenditures with these revenues. So those patterns and plenty of other interesting evidence you can find in the Hamilton Project's 9 Facts about monetary sanctions, which if you haven't already grabbed, you can get outside. And then, so what we want to talk about is the set of reform options that this evidence base prompts. And I think that's driven by this growing research literature that documents the costs that these sanctions impose on people with criminal records, but also documents the extent to which the system is not always effective at achieving its own goals. So researchers have learned how law enforcement behavior can be distorted by the incentive to acquire and retain criminal justice revenues from sanctions. And we're going to talk about what can be done to simultaneously achieve objectives like public safety while minimizing the harm to people with criminal records. So with that, we'll get started in a moment. I want to remind you that we have a Q&A process that's a little different here. So we'll be passing around note cards on which you can write any questions you have. Those will be passed up to me, and we'll have a Q&A period at the end. But first, what I'd like to do is turn to one of our authors, to Michael Michalski, and just to ask him to kind of describe the challenge that he's addressing in his proposal. So you're focusing on realigning the incentives of law enforcement. Can you just tell us a little about the problems that motivated you to write this?
Yeah, let's set a little public finance context. So for local governments, raising debt is hard, raising taxes is even harder. If they do manage to raise taxes, someone's probably going to lose an election, or your tax base may just decide to live somewhere else. So facing those constraints, what a lot of local governments have elected to do is transform their local law enforcement into an effectively regressive tax system. And this strategy has spread across the country. It's becoming more and more common. And I think for a lot of us, when we put the image in our head of revenue-driven law enforcement, we think immediately of speed traps. We think of sort of nuisances, parking tickets. But if you look at the growing body of literature, and Professor Colgan's part of this, these are not nuisance fines and fees. These are often financially crippling. They're sizable enough that people are being incarcerated for failure to remit payment. And furthermore, it's extended beyond citations now. We're seeing correlations between criminal arrests, especially criminal arrests that can lead to property seizure. So now we're talking about a system that is both financially harmful, but is applying this criminal stigma to someone for the rest of their life. And furthermore, it's part of a system that we're seeing a lot of systematic bias. So when we see a correlation between increases in arrests, we're almost exclusively seeing that for our minority arrestees. We see essentially no marginal correlation for white arrest rates. And you know, statistics can seem a little anodyne, and maybe that's sometimes why this can fly below the radar. But the report that the Department of Justice issued on the municipality in Ferguson, Missouri, in the wake of that tragedy, presented such a stark image, just irrefutable evidence of a municipality where the criminal justice system had become systematically biased against low-income African Americans as a fiscal strategy. And when you combine that fiscal strategy with law enforcement, creating this incredible amount of collateral damage in pursuit of, from a public finance point of view, which would seem like a relatively modest amount of revenue, it becomes a destructive enterprise. So what I'm proposing is essentially two strategies in pursuit of one goal, which is revenue-neutral law enforcement. And it does that through two things. One is subtle, and that's the pooling of criminal justice revenues across all municipalities within a state and remitting those back to the state to then be distributed on a population basis back. And I know it might seem kind of odd to suggest having local agencies give money to the state only to have it sent right back without any change in the quantity, but that remittance dilutes the incentive from any one arrest. So in that moment of discretion that the officer has, that arrest isn't going to actually put any more money in his or her budget, in his or her overtime allotment. It's not going to keep their boss any happier. It's been just diluted out, and then it will come back. But we also know there's a lot of political games that can be played. Politicians are very clever in terms of moving money around, which is why my second proposal is more ambitious. And that is the establishment of a public safety rebate, where the direct revenues from arrests, so the penalties associated with it, the property seized, would be pooled in the state and then rebated back at the end of the fiscal year to low-income constituents using the SNAP program rubric. So there'd be minimal overhead. But it's returning this money that has already served its purpose. It's served its purpose as a deterrent, but now it's never going to actually enter a budget. So when members of the community receive this rebate every year, it's informing them what law enforcement is doing in their community, but it's also it's establishing a commitment and making a promise that we're using these penalties because we don't want to fall back on incarceration. We want them to be a deterrent. But once they serve this purpose, we're giving this back to you because we're here to serve and protect you. We're not here to take from you.
Great, thank you. Beth, so I'd like to turn to you now and ask you to kind of tell us a little more about the problems you're addressing in your proposal. You focus a little more on the individual side of monetary sanctions.
Sure, absolutely. So just before I get going, I want to talk a little bit about the scope and type of sanctions we're talking about outside of the forfeiture context. So there are, roughly speaking, about 4 general categories of economic sanction that are widely used in the United States. So a statutory fine is the one we think of most often, but there are also fees, administrative fees that are charged for things like if you have a jury trial, you have potentially have a fee. If you might have to pay for the costs of your pretrial or post-conviction incarceration. One that often surprises people, you might have to pay for the cost of the public defender you only qualify for because you're indigent. So these fees can stack up. We also in many places have what are loosely called surcharges. So these are additional items that operate as essentially fines on top of fines. They're often targeted for particular pots of money. So you might have a driving violation that results in a ticket, and your surcharge might be used in some states to pay for the public parks fund, or in Arizona there's a clean elections campaign fund. So it may have nothing at all to do with law enforcement. And so as we were just hearing about this being used as an alternative tax mechanism, this is a particularly obvious moment where that happens. And then we also have restitution, which at least in theory is supposed to be paid to victims, although we haven't done a particularly good job of ensuring that actually happens, which I'm happy to talk about in Q&A if people are interested. So there are all of these different kinds of sanctions in play in many cases, and this happens from adult felony court all the way down to traffic courts, although restitution is less likely in that context, and also in juvenile courts. And one of the things that happens is that if you don't have the ability to pay immediately, we keep tacking on more fees, more collections costs, interest, and the like, and so that debt just continues to accrue. And if you miss a payment or fail to pay, then we have what are called poverty penalties that can be tacked on top. So this may be, again, additional economic sanctions, but it also might be an extension of your term of probation or parole. It might include incarceration in some places. In many jurisdictions, it involves an extension of the loss of your right to vote. And I should note that most of those things are arguably unconstitutional, but they're widespread around the country. So how many people are in this position of not being able to pay? Well, just some rough evidence we have about the economy, and of course, as we've heard, a lot of this is targeted at low-income minority communities. But just as a general matter, the 2017 supplemental poverty measure found that almost 14% of Americans are living in poverty. And as a result, actually a little more than a quarter of adults aren't able to meet their monthly needs. So they're having to skip things like rent or food, basic necessities. If you look at minimum wage, in most states the minimum wage, even if adjusted for the earned income tax credit, would leave a family of 3 below the federal poverty line, or rather just above the federal poverty line. So as a result, there are a lot of people that just simply aren't in a position to make a payment if suddenly they have these economic sanctions added to their monthly bills. And so, and when you add on to that 9 million households in the United States are unbanked, meaning they have no access to a standard bank account. There are no savings to draw from. That means that if they have to make payments, they might be going to more expensive options like payday loans. And so this all has serious implications for people who are unable to pay. And what we know is that people with criminal histories, people who, especially who are coming out of a period of incarceration, re-entering the community, are likely to have very limited success finding employment. Having a felony conviction on your record can hamper that. There may be actual restrictions on employment and business licensing that can attach to certain convictions. They also might be triggered by an inability to pay. And as a result, we have people, and particularly people in communities of color, who are returning to spaces where there are fewer jobs available in the first instance, are already having difficulty making payments work. So there are a number of things I'm happy to talk about in Q&A around, what is this even meeting the goals of punishment? Does this deter or not? Spoiler alert, there's evidence that actually using unmanageable sanctions is criminogenic and pushes people into crime. It has problems for system legitimacy. There are a variety of issues problems that this creates. And so my proposal, which I actually think is is not a panacea to the large-scale problems we're talking about. This doesn't fix policing. It doesn't fix the racial injustices in the criminal justice system. It makes a small contribution, hopefully, to improving fairness in terms of the use of economic sanctions where we use them. And that's to require an ability to pay calculation. And I'm happy at the, discuss later what the details of that might look like, but as a rough overview, you really need to have the criteria be objective, both in terms of a person's income and expenses. One of the things we see in places where there isn't objective information used to determine ability to pay is that it can turn on things like what shoes you wore to court. So it doesn't really give us an idea of what people are able to pay. I'm happy to talk about the day fines model for this. This is a system used in Europe and Latin America that is a particular form of means adjustment where we look both at the ability to pay and the seriousness of the offense to come up with the penalty imposed. And it's important to understand that there are going to be some people who cannot pay anything. And so we have to be serious about talking about non-incarcerative, non-economic responses to what are currently handled as criminal justice problems.
Great. I'd like to turn to Danielle now and ask, monetary sanctions are not new in the U.S. criminal justice system. What have we learned from that history, and particularly in terms of how sanctions matter for civil rights?
Thank you. It's a pleasure to be the historian in the House today and get the chance to think about the past. And so I am going to put a policy reform idea on the table from our own deep history. Probably hasn't occurred to anybody, but the American Revolution. It was indeed, a policy response to exactly this kind of problem. So let me just walk you through that history a little bit to remind you, because it connects to the issues of legitimacy that both of the previous speakers raised. So here is the text of a commission for a customs commissioner appointed by the king in 1754 by King George. I do hereby appoint you, the said George Stewart, my commissary, in the said province and territories aforesaid during pleasure. This was in Maryland. Hereby granting unto you, the said George Stewart, all fees, profits, and advantages to the said office, any ways belonging. And I do hereby command all justices of the peace, mayors, sheriffs, keepers of jails, and other officers and ministers within this province to aid and assist you as becometh, as they will answer the contrary to their peril. This commission, in other words, explicitly paid for the customs officer and also, by definition, the folks assisting him through the fines, fees, and asset seizures that he would be collecting as a part of his job. This, the American colonists rejected mightily, as you all know. And basically what happened was that had been the standard way of funding a set of offices. And then after the French-Indian War, the British government was in significant debt and saw the colonies as a source of revenue extraction. And so they self-consciously, just as in these cases, converted their concept of the administration of justice from one that was about justice and legitimacy and securing the peace to being a concept of revenue generation. And they passed a series of acts, the Navigation Act, Sugar Act, Trade Act, and so forth, prohibiting trade in lots of goods beyond specific designated areas, increased the number of customs officers. And the response of the colonists to this, again, their policy reactions was that the Sons of Liberty burned the Gaspé in Providence, Rhode Island in 1772. The Gaspé was a customs officer ship that had interrupted an American ship that was transporting rum. The rum had been sent to Boston for sale as a customs prize, so Sons of Liberty burned the Gaspé. Policy proposal number 1 for the revolutionaries. Okay. And in Annapolis, another instance, a ship called the Speedwell was secured by the customs officers, and all of its goods, so not just the illicit goods, all of its goods, all the tackle, all the equipment of the ship were put on auction at the Maryland Coffee House, with the proceeds to be split between the court for its operations and the judge personally. And that, the response of the Americans was to tar and feather the customs officers. So we have a deep history of thinking about this problem, and it's in the text of the Declaration of Independence. The language of the Declaration that complains about the king sending a swarm of officers to eat out our substance is a comment on exactly this treatment of the administration of justice as a revenue generation source. The Fourth Amendment, of course, the protection against unreasonable searches and seizures, is also about exactly this issue. The seizures component about that was really focused on this revenue generation problem. So the American founders recognized that the legitimacy of a system of justice depends on that its purpose be justice and securing the peace, and sought in various ways to try to establish that. Over history, we have failed, and failed even in the 1780s and 1790s. Corrections were failing again now. And I just want to conclude by reading a poem by the National Poet Laureate, Tracy Smith. The poem is called Declaration. It's very short. And I'm reading it mainly to indicate that the issues of legitimacy and the connection to the deep history of this country and why we built a rights-protecting system in the first place has not been lost on communities of color who are experiencing this treatment. So Tracy Smith, who is herself African American. The poem is basically little excerpted bits of the Declaration of Independence. He has sent hither swarms of officers to harass our people. He has plundered our, ravaged our, destroyed the lives of our, taken away our, abolishing our most valuable, and altering fundamentally the forms of our. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. We have reminded them of the circumstances of our emigration and settlement here, taken captive on the high seas to bear. That's all from the Declaration of Independence. It all pertains to the issues we're talking about today.
Thank you. That'll be a little difficult to follow, but
Thanks.
I'd like to come to you now.
I promise you I set up the legitimacy theme, right? So I did my
Yeah,
job.
you did. You set it up.
So I was hoping you could tell us a little about the contemporary political context of monetary sanctions, particularly as they relate to punitive excess. So I think it does follow nicely.
So first, thanks to the Hamilton Project for the invitation. Honored to be on this panel. Special tribute to Secretary Rubin, who's been a voice for justice reform, and have just think of the Secretary of our Treasury being a voice for justice reform is powerful. So I want to make 3 points. The first, just by way of introduction, is to thank Professor Mikowski for citing the Ferguson report. So in many ways, we're here in memory of Michael Brown. I mean, that report, occasioned by his death, I think really brought to national consciousness the practice that we're talking about here in its extreme version, but not its uncommon version. The big point I want to make is not the back to the revolution, but just to remember where we are in our country in terms of the use of the criminal sanction that has morphed over the last 50 years into an instrument of repression. So we have, as the Secretary mentioned at the outset, quadrupled the rate of incarceration in the United States. And a number of people, including my colleague Bruce Weston and I, have written about this. National Academy report documents how it happened. It was because of an excessive use of the sanction that we'd call the criminal law to accomplish not crime control, because that was not what it's about, but in essence to reorder our society. increased incarceration rates, increased supervision rates, increased use of pretrial detention, which the next panel will talk about. And here we are talking about another manifestation of the same political era of what a number of us are calling the era of punitive excess. And that is the use of monetary sanctions as part of this regime of extended use of state power. So this is a moment where my inner libertarian comes out, surprise to some of my friends, where I say what we have done is we have weaponized state power through the use of the criminal sanction in ways that are very destructive, particularly destructive of our aspirations for racial justice. So that's the first point. We can't talk about this topic, much less bail reform in the next panel, without recognizing that we are in a unique moment of American history, and it's time to reverse everything that we've built over the past 50 years, including this. The second point I want to make is that the question of financial penalties, which I think there are 4 actually, I would agree with Beth. There's bail, which the next group will talk about. There's fines, there's fees, and there's forfeiture. That use of the state power to extract money from people who are under state control in some way has to be seen also, again, thanks to Secretary Rubin, in the context of poverty. So if you look at all of these phenomena from the position of a family that has to deal with financial realities that include not only these, but let's read Matt Desmond's book, right? Eviction, right? There are other things going on in the lives of poor families where this is one more thing on top of a strained financial reality. There are economists who have looked at what I think is in some ways one of the most damaging consequences of this era of punitive excess, which is the diminished ability, particularly of African-American families, to accumulate and transfer wealth between generations. So it's not just these that tend to depress that ability to accumulate wealth, but it's also commissary. It's also the trips to the prisons. It's also to the collect calls. So at some point you say, what have we done in this country to those who are struggling the most? Final point. I find it interesting, and this is a real contribution of the papers, to look at what we're doing here with fines and fees and forfeiture and all the financial penalties and bail in the context of the reductions of tax revenue to localities and this notion, which sounds so benign, of user fees. So we pay user fees for all sorts of things. We all pay a little extra to fly an airplane so that those TSA employees can do the work they do to make sure we're safe. Fine with me, I'll pay more to make sure we're safe. User fees, as applied to those people who are under state supervision, is, I think, obscene. So the question here is not proposals, but it's first principles. Why would we ever charge somebody for the privilege of being supervised? Why would we ever charge people, Beth mentioned it, for the appointment of counsel when you're indigent? So the user fees notion, which comes from an interesting place, and maybe it's part of the reduction in state in tax revenue, we charge people to do certain things, just seems to me in this context to be obscene. So if we look at the criminal justice system as a public good that should be paid for by the public, because the adjudication of wrongdoing and the appropriate response to that wrongdoing is a public value that enhances the respect for the rule of law because that's a public value. And then we create this machinery that just puts people in and out of the system and charges them for that privilege. We have done something that I think has to be not only seen as not only unconstitutional, but as a matter of who we are as Americans, inconsistent with core American values.
Thank you. So I'd like to turn now to Kristen. And Michael argued that revenue-motivated policing isn't just bad for the people who are the targets of it, but it also can undermine public safety. Do you think that's right? And how have you seen this play out in your work?
Yeah, so first I want to thank the Hamilton Project for shining a spotlight on an issue that I think stands as one of the greatest threats to our democracy today, fines and fees, and the resurgence of modern-day debtors' prisons. And I think, frankly, we talk about it a lot, but there isn't enough being done to promote reform and end this pernicious practice. I think that Jeremy is exactly right, that it is in large part to the legacy of Michael Brown and what we've all learned about Ferguson, Missouri, that's helped to promote greater public dialogue around this crisis. In Ferguson, Missouri, this is a place where 20% of government revenue is generated off of fines and fees extracted off the backs of poor people, the majority of whom were black and brown, and simply lack the ability to pay. Fees tied to offenses like walking, in the manner of walking in the roadway, failure to comply citations. These are citations that were issued to about 95% of African Americans in Ferguson. Municipal violations for having an unmowed lawn, putting out trash in the wrong place at the wrong time were also issued overwhelmingly to black residents. And sadly, we know that these practices are widespread and pervasive across the country. What's remarkable is that there's actually a clear Supreme Court precedent that makes clear that this is unconstitutional. A case called Bearden versus Georgia, which says that you can't lock somebody up merely because of their inability to pay. But the problem is that we don't have an enforcement mechanism to help breathe life into that Supreme Court ruling. And so one of the things that we do at the Lawyers Committee for Civil Rights under law is we try to hold some of the bad actors accountable. We have been doing a fair amount of this work in places in the Deep South, like Arkansas, Oklahoma, and Louisiana, where these practices are particularly deep-seated. And just to kind of help bring these issues to life, let me share just a word about a case that we brought in Sherwood, Arkansas. Their fines and fees on poor people is just a fact of life. This is a town that had set up a hot checks court and made big business out of prosecuting people for writing small checks to local merchants. The court advertised their service on their website, and one of our clients kind of really speaks to how problematic the practices of this court were. One of our clients, Nikki Petrie, was a woman who 5 years prior to our filing of the suit wrote a small check for about $29. And over the next 5 years of her life, she paid more than $600 in fines and fees to this court. And when we filed, she remained indebted by about $2,600. She had no job, she had no source of income, she stayed at home to take care of a bedridden mother. There was no way she would ever climb out of that hole. And on top of all that, she had spent about 25 days in jail because of her inability to pay those fines and fees. White County, Arkansas, we brought a suit here as well. One of our clients is a woman named Nikita. Both she and her husband were entangled in the court because of their inability to pay fines and fees tied to nonviolent, low-level offenses. They lost their children because they were in jail and are still struggling to get access to their kids back. So these are practices that destroy lives and tear communities apart. We believe at the Lawyers Committee that litigation is a powerful tool for promoting reform. It helps to lay the groundwork that might help create the political will necessary to embrace some of these bold and ambitious reforms that we have been hearing about this morning. So we continue to look to the power of the courts to help to hold some of the bad actors accountable, to send a strong message to other judges and courts out there that their practices are violating the Constitution. And hopefully, if we send a strong message to enough courts and judges, we can help to institute some of these reforms that might bring about the systemic change that we ultimately need.
Thank you. Well, back to the proposals then. I'd like to come back to Michael and ask, if you want to say a few more words about the details of what you're proposing and some of the advantages that it would have.
I think the principal advantage to the first strategy, the first proposal, which is the remittance of direct revenues from arrest back to the state to then be distributed per capita, is the simplicity of it. That there's not a lot of machinery, and there's no explicit cutting of the revenues in a given fiscal year. But so if we see an effect from that, if we see a decline in arrests, in a decline in citations, a decline in the revenues from that, it is strictly going to be driven by that 5, 10, 15% of municipalities that are egregiously pursuing that as a fiscal strategy. So for the median local government, this will have actually no effect. And that's what we want. We want a policy that's simple to implement, that is going to, any outcome effects will be driven by the most aggressive municipalities and the ones that have really adopted this strategy. As for the more ambitious, the proposal to establish this public safety rebate, I think, I want to take a step back and just note that I don't think this is what most officers signed up for when they went to the academy. They didn't foresee themselves becoming an agent of a tax system. They didn't see themselves as tools to expropriate wealth from a community. And furthermore, most of these officers, they don't work their beat with a partner. If anyone's going to have their back, it's going to be the community they serve. But there's no way they're going to get that community buy-in and support and partnership if they're a walking financial catastrophe, if they're a threat in just so many dimensions. So at the margin, I think this is not just harming families and harming households, it's actually putting the officers themselves in greater danger, and at the very least, impairing their ability to execute their duty. Now, if we want to get into the real nitty-gritty, there's subcomponents, there's additional small policies, ending federal equitable sharing programs to remove the incentive for seizures and participating in drug arrests that can lead to greater seized property revenues. But I think the most important thing to establish in this conversation is the goal to dilute this incentive and to reestablish trust between officers in the community that public safety is in fact their principal goal.
Thank you. So Beth, I'd like to ask you kind of the same question. If you could just say a little more about what exactly you're proposing and how you see it working.
Sure, absolutely. So if, as I mentioned in my initial remarks, that it's very important that objective information be used to do an ability to pay calculation. And so one of the things that you want to think about in engaging in institutional design at the front end is what constitutes income, and how broad is that? Mm-hmm. Because one of the issues that is really important to understand in this context is that family members are often the people who are paying, and that's particularly true. There was a recent study in Alabama that showed that was particularly true for middle-aged African American women. So people who are not themselves debtors but are paying the debt for someone else. And so one of the things that you would do in this type of calculation is determine what income is. If a person has a job, then you assess what their actual take-home pay is. If they're on public benefits, that could be used as a source of income. If you're applying this to wealthier individuals, you might think of other things like real estate income and the like. But focusing on folks who are unlikely to have that, you then have to think about what are the parameters of whose income we're going to include. And the pressure with respect to family income is that on the one hand, if the person actually has access to that money, it seems illegitimate not to include it within what they're paying. On the other hand, we have a real and serious concern that people who did not engage in an offense are being effectively punished for it. And so we can look at models. There were a series of day fines experiments in the United States in the late 80s and early 90s that included some aspects of family income, consumer bankruptcy, federal student financial aid. There are a number of models we might look at to try to establish very clear parameters of what does and doesn't count. What I recommend in the paper is that family income be limited to income to which a person has a legal or equitable right, and not beyond that. Now, we also have to match that on the deduction side. So anyone whose income's included should be included in the cost of living deductions, right, as well as anyone who's dependent on those people. But not go any farther than that on either side to ensure that we have a clear cabined determination of what income includes. On the deduction side, it's important to think about things like daily cost of living that may be different in different jurisdictions or even different cities within the same jurisdiction. But there are, again, looking at these day fines models from the late 80s, there are ways that you can set very standardized amounts so that the actual application of this system isn't labor intensive administratively, And then you need to make sure there's some wiggle room there. So if someone comes into the system who, for instance, has very serious medical needs, you'd want to make sure that if we're thinking about what their income is, that that's captured. So once you've determined what a person's ability to pay is, the next big question is, how do you actually use that to graduate the economic sanctions? And there are really 3 different models I talk about in the paper. One is something that's been adopted recently in San Francisco with respect to traffic tickets, which is to say, if you are able to pay X amount, then you get the normal traffic ticket amount. If not, if you're below that threshold, we're going to knock 80% off the ticket. So that's sort of a sharp line below, if you fall below which you get the relief. Now, one of the concerns about that is if you're slightly above that line, you don't get the relief, and there are going to be some people who are slightly below that line who might need less relief than that. And so that's a system that could only be really useful at the very lowest end of the amounts of economic sanctions we're talking about. Another approach is to use a sliding scale, right, which gives you more granularity. And then finally, the third approach I talk about in the paper is an actual day fines model. And so just to explain what that is, you would take the adjusted daily income of the person and multiply it by a penalty unit, the result of which would be the fine imposed. The penalty unit is established by the seriousness of the offense. So jaywalking might be half a penalty unit, burglary might be 100 penalty units. And so those units are established without considering ability to pay, so they're entirely dictated by the severity of the seriousness of the offense. And that multiplication then results in the amount. So if it's a 1 penalty unit and my daily income is $10 a day, my fine would be $10. If my daily income is $100 a day, my fine would be $100. And so that's a model that we've had some experimentation with in the United States. It's used in, as I mentioned earlier, several European and Latin American countries, and so we do have some data about what that looks like.
Great. I'd like to take a step back and ask kind of what I think of as a core question here. So we teach undergraduates in the economics of crime that incarceration involves a whole host of costs, and that fines can actually be an alternative to those that are preferable in some instances, because you can deter crime, you can punish it, but you're in principle allowing people to continue to work, and you're not paying the costs of incarcerating them. So I'm wondering where that goes wrong, where that sort of Econ 101 take goes off the rails. And so this is really a question for anyone who has thoughts on it.
This is something Professor Colgan touched on, the criminogenic effects of enormous fines, which is if the fine and the time in which you have to remit payment is such that your standard occupation is just not going to cover it, you have a lot of people in a situation where property crime, where boosting becomes your best option, other than maybe taking out a payday loan. So you have 2 terrible choices. One with an incredible interest rate that's going to cripple you financially and you probably will have to default on, or the riskier option of participate in some sort of low probability of getting caught, quick payoff criminal activity. So now you're actually driving people who didn't previously have a criminal record into criminal activity because it's their best option in a terrible situation.
Right.
Again, I think we have to make some distinctions here. Set aside forfeiture. We haven't yet referenced the Supreme Court decision in Tim's, very important. There'll be lots of interesting litigation opportunities that'll keep your folks busy. Forfeiture is ill-gotten gains, instrumentalities of crime, different rationale. Money bail, next panel. But let's be clear about the distinction between fines and fees in terms of their public purpose. So fines are intended in our jurisprudence to have a sanctioned purpose. They are intended to be a type of punishment. They should be, as Beth aptly said, and constitutionally required, that they be affordable, that there be some ability to pay. Even within that, there are alternatives to that mechanism of sanction, and day fines is one. And just full disclosure, at Arnold Ventures, we're funding a lot of this experimentation. Very exciting time. We've been at it for about 5 years. We've got about $30 million worth of projects underway. So experimentation is one of the things we should be doing right now. Day fines is one. I hold out little hope, however, in answer to your question, that we should think of fines realistically as an alternative to the incarceration realities. undoing that, if we look to fines, to fines as a way of undoing mass incarceration, it'll be a long time before we get there. So I would, maybe on some cases, judges would say, I'll weigh this and that, but I wouldn't hold out that hope. Fees, however, are an entirely different beast, and they are imposed under this user fee idea. They're not intended to be, have a criminal justice purpose. They're revenue generating, with all the conflicts of interest built into it. Some courts are now starting to and it's not just police, it's also judges, it's sheriffs, it's probation officers, it's private probation companies. So that incentive, that economic incentive that is built into the fee structure is maybe at the end of the day the revenue goes to the same government, but we should think about public purposes as being very different between those two. Our view at Arnold Ventures is public good is the criminal justice system. It shouldn't be on the backs of the people who are involved in the criminal justice system. It should be paid for by the taxpayers. That's where we come into conflict with this no new taxes mantra.
Danielle, did you want to?
In some sense, it's an extension of what Jeremy said. So exactly that. That is, the criminal justice system is a public good, and so needs to be funded through taxes, reasonable taxes. And then the question is, for the sanctions applied, what are the principles that should guide and structure that? And that's where I think we may have a slightly different take on how you move the needle on mass incarceration. You have to rebuild a capacity for the country to see that the purpose of sanctions should be to make everybody whole. Victims whole, wrongdoers whole, communities whole, achieve health and well-being of the set as an extension of the peace and security concept. And I think for that, the day fines issue is a really important adjustment. We do need to bring down the frequency with which we use incarceration as a sanction. It's not the only alternative method. I think that's the important point. But sort of far reduced degree of incarceration plus day fines plus forms of diversion that take people out of the criminal system. Those are all important parts of reorienting the whole system towards a general peace, security, and well-being for all concept.
Right. If I could just jump in as well, I agree with that. And also it's important to note that when we're talking about deterrence, the idea of deterrence is that a person can make a meaningful choice about whether or not to operate within the confines of the law. But there are a number of things that we charge economic sanctions for where there is no such meaningful choice. So when we charge a person who is unsheltered for trespass, for sleeping in a public space, they don't have a meaningful choice to operate within the confines of the law, and we're still adding to their burden fines and fees that will never be paid, right? And so a part of this conversation, I think, too, and we're talking about incarceration because that person is going to end up in jail at some point because we've put them in the system, is that we have to talk about why is that a crime, right? Why is it that that has been criminalized? That's a key part of this conversation we have to have.
And let me just to, again, lift up the power of litigation. We actually sued 13 judges in the city of New Orleans, a case called Kane versus the city of New Orleans. It's a class action brought on behalf of poor people, overwhelmingly African American, who were incarcerated. Judges failed to consider their ability to pay. And one of the powerful things in the decision that we got from the court last year was a recognition of the unconstitutional conflict of interest, where you have judges who are imposing these fines and fees, and it really underscores how we can't look to courts and judges to self-police here and to impose the reforms that ultimately are going to be necessary to turn this system on its head and bring it back into conformance with the Constitution.
And I can just tack on one thing. I see so much in the fee structure of the criminal justice system right now is this sort of fool's gold ambition of a free lunch, that we can have a criminal justice public good for free because the criminals will pay for it. And that's the sort of implied message. And if there's one thing we know over and over in economics is that this is just, it can't be had. If you want to have a true public good provided, you're going to have to pay for it.
That makes sense. We're getting a lot of great audience questions, so I want to turn to those. The one that's come up the most is sort of to ask you to think about how this is all interacting with the ways in which we've privatized the criminal justice system in various respects. So there's a number of different angles on this, but I just wanted to kind of toss that out generally.
So Craighead, just to come back to Arkansas, Craighead County, Arkansas, an interesting place. Judges are elected. You have 2 judges who ran for election on a platform of reform. Their end goal was to improve some of what was broken with the criminal justice system in this community. They won. And one of the first things they did was they terminated a contract with a private probation company called Justice Network that had profited and extracted hundreds of thousands of dollars off the backs of poor people in this community for years, and decided that they would put in place a better system, one where they would think carefully about people's ability to pay. I mean, people had been locked up in this community because of their inability to pay. This predatory private probation company that would, knock on people's door. They cooperated with police and, threatened arrest at every turn. Remarkably, that private company sued the judges. And it's a case that's moving forward now. We've weighed in and offered up an amicus brief in support of the judges, but it just underscores the dangers of privatizing aspects of our criminal justice system and the sense of entitlement that so many of these predatory companies have. I think that it's important for the public to be vigilant when we hear discussions about cities, counties, government in general entering into contracts with private companies. The situation, I think, in Craighead County is just emblematic of so many of the problems that riddle communities across the country that privatize.
Can I flip it just a little bit? We often look at private probation, private prisons as sort of the devil incarnate. And sometimes and they do terrible things, but we shouldn't let that question, a legitimate question, distract from the fact that we have elected people through our democracy who are doing what we're talking about. Judges, DAs are complicit, certainly financial officers are complicit. So I just want to keep the focus on this is us. We have created this system and we can undo it. What I find encouraging, in addition to the litigation victories, which are spectacular, is counties, boards of supervisors, San Francisco, they created a some task force, I forget what it's called, financial justice task force, and they have decided by ordinance just to stop doing it. State of California, stop imposing fees on juveniles through legislation. So what's happening in the justice reform movement now, which is very much grassroots up, should grab onto this issue. And just like there are progressive prosecutors being elected, there should be progressive fill-in-the-blank mayors and others who will say, we're just going to stop doing it. And that's a different proposal from the ones we're hearing from our academic colleagues. But I think that has to be the way to think about it, and stop feeding the private beast.
So actually, I think of these two things as two sides of the exact same coin. And what it comes down to is power and discretion being traded. And in one case, it's put in the private marketplace, and it's being exchanged and turned into profit. And in another place, in the political marketplace, that power and discretion is being traded for revenue and votes and political support. Mm-hmm. And both are terrible outcomes. But the seed underneath both of them is that power and discretion in the criminal justice system that can then be exchanged. And so much of what we have an obligation to do is try to mitigate that discretion and how it can be employed.
So unfortunately, we don't have much time left. There's lots to talk about, many great questions I wish we'd had time to ask. But what I'd like to conclude with is, I guess, a question to everyone but the authors, to sort of tell me briefly, sort of what are you either most optimistic about being able to fix fairly soon, or a different take, what should we be pushing on? What is the thing we haven't discussed until now that you think should be getting more emphasis? So maybe we could start with whoever would like to begin.
Well, I'll repeat what I said before, which is to say I think that the day fines model for the sanctioning part of this is a really important one to move forward. And it has been used extensively in Europe. Germany and the Netherlands are the two cases that are typically held up as places where rates of the use of incarceration. So in the US, Incarceration makes up 80% of our sanctions. In Germany, that number is about 6%. I'm not going to get this exactly right. In the Netherlands, it's 7 or 8%. So a lot has to be decriminalized to get there. That's a part of it. But you also have to have a much broader set of alternatives to incarceration. And I think day fines is a really critical part of that. That would be point A. And then point B, I would echo Jeremy and say just putting an end to the fees part of this, which are meant to be the sort of way you fund the system, rebuilding the concept that it's the administration of justice is a public good.
I'll just say briefly, I think the attention being paid to criminal justice reform, long overdue, is just electrifying. I think this issue has not gotten sufficient attention. I also think it's a mobilizing sort of point of focus for those who are doing the hard work at sort of ground level. But it's also up to, where are the journalists? So follow the money. Where are the folks who are, the conflict of interest litigation victory that you want is so important conceptually as well as legally, that there's an inherent conflict in paying for the operations out of the fees, target fees, not fines, of people who are under supervision. That's egregious in the private case. So there's an exposure opportunity here that I think we're just starting to see emerge. And the other, what I reference is so localities, whether it's Cook County or New Orleans is one, or Alameda County, just taking hold of it. This is about us. We're doing this. It's in our name, and we can stop it.
And you know, the bipartisan support that we're seeing for criminal justice reform right now is indeed inciting, and I think reason to be very hopeful. And I think the resurgence of modern-day debtors' prisons, Jeremy is exactly right, is not getting the attention that it should. It is a problem that is impacting overwhelmingly African American, Latino, low-income communities, destroying communities, pulling families apart, entangling people unnecessarily in our criminal justice system who pose no threat to public safety. At the end of the day, we're talking often about offenses that don't even rise to the level of being a crime. And you know, this wastes taxpayer dollars, and I think ultimately endangers communities because we're you know, not focusing on the real threats and real issues that beleaguer communities. We've issued a report today that looks at these problems in Arkansas in a real systematic way, and I think it speaks to a problem that's pervasive across the country, and I'm hopeful that we can find the bipartisan coalition necessary to achieve reform across our country.
Thanks so much to all of our panelists. We're going to have a brief break, and we'll see you for the second panel.
They're fun. So the poem, I've got to get there.
Yeah.
Good morning. Morning.
Good morning.
So that was a fantastic first panel, and I think both set up this conversation well to continue essentially what was discussed. And I won't, following Jeremy Travis, because, New York is in the house, I really wanted to both appreciate the conversation about principles that the previous panel shared, and really tee this conversation up with what for me became personal, even though it wasn't personal, to really frame, I think, the principles of what we're talking about here, which is Kalief Browder. So many of you all will know the story of Kalief Browder, but even if we do, it's important to remember it. Kalief Browder was 16 years old when he was arrested for allegedly stealing a backpack. As a result of that arrest, he ended up spending 3 years in Rikers Prison, 2 of those years in solitary confinement, for 2 reasons. One is he refused to plead guilty because he says he didn't do it. And that's one of the reasons he actually spent so much time in jail. And that's an important part of the story to remember. And then the second was that the judge, both the prosecutor requested and the judge imposed $3,000 bail. Now, the way the story ends, besides 3 years in prison, 2 of those years in solitary confinement as a teenager, is that he committed suicide after his release. Jennifer Gonnerman, who wrote the story that brought this individual story to light, was really bringing to light a story of a system that doesn't work. And I wanted to frame that out because at all points of Kalief Browder's story, there's the police and the police officer's decision to arrest him based on what was some really shaky testimony and discussion with the police officers at the point of arrest. And then there was the prosecutor's use of their effort to extract a plea deal that resulted in bail, and then his inability to make that bail, and his refusal in the absence of not having the money to be kept in jail for that length of time without having been convicted of a crime, which is also then about the backlog of the judicial system itself in not even being able to bring that case to trial to determine if he was even guilty. And I want to share one other, because at the time I was in the de Blasio administration as his counsel. So one of the things that the city started doing, which I think is also important, in the absence of state legislation, because we are going to be focused on solutions here, in the absence of state legislation, to start doing as much as the city could to reduce both the number of people who are even being taken to jail in the first place in the form of telling, and the city council was hugely important in this, and stopping arrests in the first place and saying, we just summons people or give them desk appearance tickets. problems there too, but really important for people not to spend any time in jail. And we ultimately also included creating a social worker who was actually attached to the case, so that as a result, people were not only spending less time in jail, there was, so literally, we're I think up to 11,000 people who've avoided jail now as a result of the reforms, but 87% of them returned to court. So a lot of the reasons why we say that we're putting up bail, we've been able to demonstrate that there are ways you can work the system to ensure that people come back, which is, I think, some of what we're going to talk about. But I really wanted to frame it around Kalief Browder, and it's not just Kalief Browder, and not all of the damage results in suicide, but that we're really talking about real people. And we're talking about people who are often caught up in a system that doesn't work for them, where bail becomes one part of systemic abuse. So with that, I want to start with you, Jay, in telling us what we've learned and what that tells us about possible solutions.
Okay, great. Thanks very much. So I'm going to try to represent the views in a sense of Will Dobie and Crystal Yang, who authored what I think is a great paper and proposal for us at the Hamilton Project, and lay out some of what they sketch out about the pretrial system, and in particular about the use of bail. As Bob Rubin mentioned in the open, last night, if it was a typical night, there were probably about 500,000 people in jail in America who had not been convicted of a crime. And about 90% of them, a judge had said could go out if they could pay a certain amount of money, but they couldn't, and so they were in jail. And so that's just this incredibly stark fact, I think, about how widespread the problem is, and we can think, and I think I'm really glad you opened that way to think about what this means to an individual, and to then think about how many individuals it's happening to every night. Bail use is up across the country from decades ago. We used to let a lot more people out of jail after arrest, release on recognizance. It's across a wide set of offenses. If you look across all types of felony offenses, it's not just that we said 20 years ago, oh no, we're letting too many people who are arrested for violent crime out, we need to change that. No, across a whole range of offenses, we require bail more now than we used to, instead of just letting people out, release on recognizance, assuming they'll come back for trial. Bail is incredibly expensive, which I think, as the last panel talked a lot about poverty in America, and it's just incredibly important to remember, the people involved in the criminal justice system are disproportionately poor. If you look at the average incomes of people arrested, as an economist, that you actually initially doubt that they're right, because the numbers are just way too low relative to median incomes and things like that, until you realize just how disproportionately poor the people being arrested are. So when the median bail for a felony is over $10,000, there's just a wide swath of people who there is just literally no way they're paying. Even though they can, in many cases, in many states and jurisdictions, they could go to a private bail bondsman, they could pay a 10% premium and have that bail posted. But if your bail is $12,000, that 10% premium, there are a lot of people, there's no way they're paying $1,200 out of pocket. And so they're in jail. It's also, though, in many cases, not just these high ticket numbers. If you go back a few years in New York City before some of the reforms Maya was talking about, you would have almost half the people who were in jail on bail for felonies had amounts of $500 or $1,000 or less. So it's not that they were being given high bails intentionally to keep them in jail. These were people who a judge was perfectly fine with them going free, but $500 or $1,000 was just financially not going to happen, and so they stayed in jail for long periods of time. And what I really want to focus on is what I think the real contribution of this paper is, which is looking at the impacts of pretrial detention. Because you're assigned randomly to a bail judge, that is in some sense a goldmine for economists, because it gives you this randomness that you can then look to see what was the causal impact of being stuck in jail. And what it lets you do is say, well, some people get a tough judge in terms of how much they keep someone in jail, and some people get someone who's more flexible. If you get the more strict judge, you're stuck in jail. We can compare outcomes for kind of an identical person. And what you find is you're far more likely to be convicted of a crime. You're far more likely to plead guilty to a crime. Interestingly, you're not more likely to spend more time in jail after adjudication. And I think this goes to the point Bob Rubin raised at the open, is often what you're doing is pleading guilty for time served or probation. but you've got a criminal record. And so 2 years later, you're much less likely to be employed, you're much less likely to have incomes, and you're much more likely to commit crime again. Because you now have a criminal record, you're probably less employable in our labor markets. And so just very quickly, some of the policies you could take, and then I'll move on to our far more knowledgeable panelists. But a dramatic reduction in the Dobie and Yang say there's clear evidence that at the margin we're detaining far too many people. It costs $50,000 to $100,000 to society to keep someone in jail pre-trial, not the cost of keeping them in jail, but the long run cost overall. And there's clear evidence that we should be moving far more to release on recognizance, to never bringing someone into jail to begin with. And you can do things to make sure they show back up. It's as embarrassingly simple as things like text messages, writing the summons forms so a normal person could read it and know when they have to show up. Things like that can fix the problem of people showing up. You don't need to house them in jail to get them to show up. And then beyond that, you could do more in terms of non-cash, non-incarceration ways to track people if you think there is a risk, whether it's ankle bracelets, whether it's just meeting with someone once a week to make sure that they're still around. There's a lot more we can say about that, but I'll leave it now to the rest of the panel. It's clear there's a system that's keeping too many people in it, and there's almost a huge number of ways we can improve that.
Thank you. So, Joanne Wallace, coming from the perspective of the National Legal Aid Defenders Association, both, share with us the experiences of people who are actually really suffering under the bail system, but also what other systemic issues you see. I know you may want to talk about in terms of what contributes to the problem.
Sure. So I know we're talking about economics, but I want to start with values, right? So school children, every day, they pledge allegiance to a symbol that stands for this country, and we tell them that it stands for liberty and justice for all. As originally conceived and created, bail was consistent with those values. It was about creating an incentive for people to come back to court, so an incentive for people to come back to court for their hearings to stand trial. It was about letting more people out of jail while they're waiting for their trial. But instead, its purpose has been totally changed. Instead, our jails are filled with people who, as people have said over and over again this morning, are presumed innocent. They're not convicted of the crime for which they're charged. Indeed, many of them not convicted of anything. But they're locked up simply because they don't have the money to pay their way out. So almost every day we see a new story. You can read about someone who's been harmed by the system of bail that is in too many jurisdictions, like Mr. Wolf in Chicago. A cell phone captured him, thrown to the ground, and then he got charged with assaulting police officers. He spent 3.5 months in jail because he couldn't afford to get out. In fact, the money that his family was going to be used to pay his bail or his bond had to be used because his uncle died and they needed it for funeral expenses. So, but depending on the jurisdiction, people who are in that situation are anywhere from 30 to 75% of the jail population. And for people of color, there's this double whammy, right? On the one hand, African Americans, Latinos are disproportionately impacted by poverty. And on the other hand, they are more likely to get a higher bail set for the same offense that their white counterparts are getting lower bail set. And they are less likely to be released on their own recognizance. So at the end of the day, when people are locked up because they can't afford to pay, it is destabilizing on individuals, on families, and communities. They lose their jobs. You can lose your home. You can lose your ability to take care of your family, your loved ones. And in addition, physical and mental health issues that existed before people are in the system can be exacerbated. I mean, first of all, by the stress of everything that's happening to you. And then secondly, because of inconsistent or non-existent medical treatment that often exists in our jails and prisons. So the bottom line is that locking people up just because they can't afford the price of their freedom. It's, you know, it's unfair, it's un-American, and it doesn't have to be that way. In fact, we are having this conversation in a jurisdiction that has approximately a 90% release rate of people who are charged with crimes. And they're a very low rate of recidivism. In fact, the last figures I saw for DC were about 90% of the people who are released pretrial actually do not commit another crime, and the small percentage of those who do, they're nonviolent offenses. So we have a model. We have models, indeed, that the system of bail and the harms do not have to happen. So in DC, it's not that you can't use money bail, but it is prohibited as a means or a reason for detention. And instead, what has contributed to those very impressive numbers are, number one, having a preventive detention system where there are procedural safeguards. It's having a well-resourced pretrial services agency. It's having a well-resourced public defender service that provides zealous representation. There is no one way to address the issues and the concerns that we have all been talking about this morning. So in DC, when you come into court for the first time, you have an attorney there. And that's really where I want to end. The reality is people who are not in the criminal justice system are really shocked when you tell them that all around the country, people come, they get arrested, they go to court for their first time, stand in front of a judge who's going to decide whether they get to go home or not while they're waiting for their trial, days, weeks, months, and there's no attorney by their side. There's no counsel to guide them. And it's something that we're really not talking about very much in terms of the bail system. When we talk about bail reform, pretrial reform, we're not really having that conversation about the intersection between counsel and how it impacts what happens to individuals in the system. So I'll end there to say much more to come, but at the end of the day, counsel is a key part of being able to ameliorate the economic impacts of the bail system that we have, as well as really challenging the system to make sure that the tools we put in place are used appropriately and properly, help us to do better, to develop better tools, better systems, by helping us to make sure that promising innovations, to tease out promising innovations, and to also reveal junk science where appropriate.
Thank you. So Professor Alex Tabarrok, I mean, you're an economist, maybe the only one on the panel, which means we're going to really test your skills. Tell us, so obviously implicit in some of what we're hearing in the discussion about reform is whether or not cash bail should exist at all, right? So should it exist? Shouldn't it? What's your view?
Yeah, so I guess my role on this panel is to be the bad guy, which Anthony Hopkins says those are the best roles, so that's okay. Look, I have 2 points to make. First of all, the paradigmatic case for the movement to eliminate cash bail is a person who is innocent, who is wrongly arrested for a minor crime, who rots in jail because they can't afford bail. As you pointed out, these cases do exist. We have such cases. They deserve attention. However, they are not paradigmatic. I want to give you some data from New York City. This is from a paper by Kleinberg et al. It covers 500,000 arrests between 2008 and 2013. 35% of the arrests were for a violent crime, including 12% for murder, rape, or robbery. Violent crimes were the single largest category. Drug misdemeanor cases were 12%. Most of the arrested people had prior interactions with the criminal justice system. So on average, each arrested person had 3.2 prior felony arrests and 5 prior misdemeanor arrests. Convictions were less than arrests, which suggests to me maybe that the system isn't convicting enough. though interpretations will obviously differ. Nevertheless, the typical arrested person has been arrested multiple times previously. Now, given all this, I think actually most Americans would be pretty surprised to find that most people are released. 2/3 are released off the bat, and then more are released when they are assigned bail, and then they make bail. Now, it is true that quite a few people who are assigned bail don't make bail, and I'll come back and talk about those in a minute. Of the people who are released, given their extensive history with the criminal justice system, it's perhaps not surprising to find that 15% fail to appear on the day of their trial. A whopping 25% are rearrested before trial, including 3.7% arrested for a violent crime and nearly 2% arrested for murder, rape, or robbery. Now, these are rearrest rates, which are almost certainly a underestimate of crime rates. Now, what role does money bail play in this? Well, first, the people who do not make bail, they're obviously not a random sample of the people who have been arrested. The people who do not, the people who do not make bail are on average more dangerous. They have twice as many arrests and twice as many convictions. For example, the average defendant who doesn't make bail has 6 previous felony arrests and 4 previous failures to appear. 4 previous failures to appear, the average. Now, what's going on here actually seems pretty obvious to me, is that there is a group of people whose job is a crime. And when they are arrested and released, they go back to their job. And they continue to do this until they are convicted of a crime and spend some time behind bars. So that's point number 1. Point number 2, I just want to say a brief word on some of my work with Eric Helland on the bounty hunter system, on bail bondsmen. Because most of the people who are assigned bail, they don't have the cash, so they borrow the money from a bail bondsman. That gives the bail bondsman a strong incentive to make sure that the person appears for trial. And they actually do this in a lot of interesting, beneficial ways. They remind the people, they call them up, they send them text messages. The bail bondsman is actually a unappreciated help to the defendants, helping them to navigate the system. Second, if they do fail to appear, the bail bondsman can send a bounty hunter after the people who fail to appear. And it's really the bounty hunters are really the only people who systematically go after and bring in people who fail to appear. The bounty hunters are really the long arm of the law. And my colleague and I find that people who are released on commercial bail are 28% more likely to show up. And if they fail to show up, they are 50% more likely to be caught quickly and to not be at large within a year. So my points really are this, to summarize, is that when we're talking about a radical measure, such as eliminating cash bail, we need to focus on the paradigmatic, the actual average cases, the paradigmatic cases of the people we're talking about. If we're eliminating cash bail, yeah, we're going to let some innocent people go, great. But more often, we're going to let the guilty people go as well. So we want to be aware of who we're talking about. Second, if we eliminate cash bail, we eliminate the bounty hunter. And the bounty hunter is one of the highly incentive systems which actually work, and we need to keep that in mind when we're doing so.
Thank you. And so I want to assure everyone we're going to have a good discussion about what strategies are and why we need to think of that. But Robin Steinberg, coming from the Bail Project, so you've been working on National Bail Fund, but also seeing what's happening locally around the country. So can you share both your experience with bail reform, and also if you want to chime in on any views, we will come back to the conversation, but feel free.
Sure.
First, I appreciate the comments of my fellow panelists, and particularly Joanne's comments were a powerful and painful reminder of the human cost of injustice, right? The cost that I witnessed for 3 decades as a public defender in one of the most under-resourced congressional districts in the nation, the South Bronx. And there's obviously the human and the moral cost here. There's also the economic price that some of us have referred to here, that we all pay. Right? We spend $14 billion every year holding people in jail pre-trial. That's $38 million a day. And when you factor in the collateral consequences, actually the estimates run as high as $140 billion annually we spend holding people in jail cells who haven't been convicted of a crime. And it's already been talked about that the number of human lives that we're talking about are staggering. It's 500,000 people sleeping in the jail cell tonight. We think that probably affects 2.5 million people every year. And that's because we churn in this country 12 million people through our local criminal legal system across this country. Each one of those numbers, and it's important for us to remember that, is a human life. That human life is connected to a family, and that family is connected to a community. But one of the things that makes a conversation about bail reform so incredibly complicated, and why I think we have a hard time finding solutions and why they can be so elusive, is that we wind up focusing on the wrong thing. Rather than dive into the facts that actually describe the big picture and have rational conversations, our minds tend to drift to the rare and the hypothetical, the unforgivable and the scary. And maybe that's human nature. Maybe it's the result of the narrative of fear that has paved the way for mass incarceration in this country and has been carefully burnished for decades to justify the worst excesses of our criminal legal system. Or maybe we all just watch too much Law and Order. But whatever it is, it takes us down the wrong path. Rather than look at what usually happens or what most people do, we wind up creating a system designed to protect against the very rare thing that might happen. We wind up, in other words, legislating around the exception. We don't do that in any other area of our lives. We take risks daily, calculated risks. We get chemotherapy for cancer treatment. We drive cars even though we know there are fatal accidents that happen every day, because the numbers of people on the road in cars every day is huge, and the tragedies by comparison are incredibly small. So we get up in the morning and we drive to work. Focusing on the exception can be a distraction, and in the context of the criminal legal system, frankly, it leads us to justify some of the most horrible things we do, from torture and solitary confinement to the death penalty, just to name a few. So let's not do that. Let's talk about the things we know, not the things we fear. So, yep, I have to address just a couple things that Alex said before I move on with my comments. But by focusing on the exception, by focusing on the scary, by telling us about all the felons that are going to be out on the street, it's to scare us. Because if you scare us enough, you will get Americans to justify doing anything, even granting a bunch of barely regulated, sometimes lawless vigilantes, some of whom, like Dog the Bounty Hunter himself, have actually been convicted of murder themselves. But since some people like to shoot from the outside, using the outliers to justify our current pretrial system, I want to join that game for just one quick moment. Let's look at what actually happens when you release those charged with the scariest of offenses, murder. Data from 2009 from the Bureau of Justice Statistics makes clear that when people charged with murder were released pre-trial, 95% of them returned to court, and 0% of them were rearrested while they were out on bail. That data really leads us to question whether even in the most serious of offenses, pretrial detention is necessary or even justified. But let's talk about some of the recent and reliable data and what it teaches us. Not many states have yet embarked on statewide or genuine system-wide reform, but a few have, and they shed some important light on this very complex issue. We can start in New Jersey, where in 2017 they passed the Criminal Justice Reform Act that overhauled its pretrial justice system to include a presumption of release for most people, and a prohibition of the use of cash bail except in the rarest of circumstances. And in the first year, New Jersey reduced its prison population by 20.3%. What did the data then tell us about crime rates? Well, since that statute passed 2 years ago, violent crime rates have fallen by almost 30%. And then for a second, let's look across the river at New York City. Just this week, new data was released from a study that analyzed 5 million cases between 1987 and 2018. And what the study found was that the pretrial release without money bail in New York City has risen from 50% to 76%, and approximately 3/4 of the accused are now released on their own recognizance, meaning no conditions or cash or ankle monitors, as compared to the national average. As a result, New York City is one of the least incarcerated major cities in America, and much of the improvement stemmed from the last few years. But did people come back to court? In short, yes. New York City's return rate to court is 86% compared to 75% nationally. And perhaps most important, and the thing to remember, is New York City's crime rates have continued to plummet, making New York City one of the safest cities in America. So when we're talking about reimagining a pretrial justice system without money being used as a proxy for race or for class, we need to center ourselves in the conversation and ask ourselves, what would you want if your loved one were in the system? For some of you, that may seem unimaginable or too far-fetched, but it's probably not for the person sitting next to you, or the person sitting in front of you, or the person sitting behind you, because new data shows that 1 in 2 American families have had an immediate family member booked into a jail. We cannot afford to have bad policy driven by the exception. So how do we find our way and re-envision a fairer pretrial justice system? Well, the answer may be simpler than you think. It may just mean building into our system a presumption of release for most people. And the data that we've been collecting at the Bail Project, as we have scaled across the country, we are learning more and more as we do that. We're now in 11 sites across the country where we're using philanthropic dollars to bail people out, providing an immediate lifeline to get people out of jail, but also tracking what we're learning and understanding what people need when they get out. We've tracked the data, and what we have learned is that, in fact, most people will come back to court. In our inaugural site in St. Louis, 94.4% of people came back. Case dispositions are more positive. St. Louis City, like in the Bronx, where we started our proof of concept some 12 years ago with our first revolving bail fund, over 50% of the cases were dismissed. But what we're also learning about, and it's my final point, is that the barriers to coming back to court are rarely intentional and purposeful. Instead, they are often connected to poverty and the lack of access to simple things like transportation or childcare. It's important for us in the field to remember to distinguish, not just use the dumb, blunt instrument of the data failure to appear, but to actually separate intentional failures to appear from the things that are related to poverty and lack of access to resources. I met a woman in Oklahoma who had to choose between buying a gallon of milk and a gallon of gas to get to court. And those myriad obstacles are unique in every jurisdiction. So as we roll our project out over with a portfolio of 25 representative sites across the country, we will be unpacking what those myriad obstacles are. But I think we're going to wind up exactly where we knew we would, which is that allowing people to be with their families and communities while their cases are pending is not only a viable thing to do, but it's efficient, cost-effective, and can help us balance the scales of justice so that everyone in America, regardless of their wealth or race or background, is afforded no more and no less the basic promise, but still unrealized commitment our Constitution has articulated, that there is supposed to be equal justice under the law.
Thank you. I just want to know, I heard agreement between Alex and Robin. So you both agree we shouldn't use the outlier as the example, and you both agree that the number of people who return is actually very high, depending on how you view 15%. So, just saying.
Yes,
Just
correct.
Okay. So I do want to turn to Jamie from the Vera Institute, which is an incredibly important institution. Again, I said New York's in the house. But tell us, so you work on prosecutorial reform. We've been talking a lot about different parts of the system and how it impacts why people are detained. Tell us a little bit more about the prosecution side of this and what reforms we need to think about.
Thank you, Maya, and thank you both to Brookings and the Hamilton Project for the invitation and for this really, really important conversation. I think before I dive right into the prosecutor's role, I love the way the conversation has been centered in personal stories and really how this issue is just one of many in a broader problem with our entire criminal justice system. So this is just one aspect that we're focusing on today. And so I want to start by just sort of sharing my personal story, because I think it basically ties together in some of these themes that we're already showing or talking about. So So I was a prosecutor for 12 years before taking this role at the Beer Institute of Justice. And about 10 years ago, as a young prosecutor working in court, I received a call from my younger brother. And he had never been in trouble before. In fact, had left college to go into a missionary program, had served on the mission field, believes he has a calling of ministry on his life. And he called me from a jail cell. And that was probably the most shocking call I've ever had in my life. It just was completely unexpected. And he was in jail in Jackson, Tennessee for stealing from his job. And what we learned over several months is that he was stealing from his job to support a substance use disorder he had been struggling with for 15 years. So his entire adult life that we as his family member knew nothing about. We knew nothing about. And so what that process, so he was held, he was not with no criminal record, not committing a violent crime. He didn't even have the opportunity for bail. He was held pretrial. It took about 3 months before he had the opportunity to plead. He was charged with 32 felony counts for each instance of returning an item of clothing and keeping the money, and had to plead to 32 felony counts to be able to get out, which is what we know happens, that people plead guilty to get out. And then, you know, as we know how substance use disorders are, on release, he failed and ended up back in jail for a year before he could actually get out and get connected with the program that really did help him change his life around. And so, so you can imagine as a prosecutor going to court every day, having the job of asking for people to be detained. This personally just impacted how I viewed everything I was doing. But in terms of how this is just one issue in a broken system, the other piece of my story that I think is important is that I'm also the daughter of a father who was the victim of a heinous robbery when I was in high school that resulted, he was beaten so badly he was in intensive care for nearly a month, thought that he would die, and suffered a closed head injury that changed all of our lives, that he still suffers the impacts from, and that was more than 20 years ago. And I can tell you as a family, having watched so closely my father go through something so heinous and traumatic, we did not call the police to find out if they ever got the guys. I don't know to this day. I assume they never got them because we never got a call asking us to get involved in a process. But no one, not one person ever called to see what happened, what investigation did you do, because we didn't see anything in the system that could offer us anything that could make us whole from what had happened or any real avenue of safety from that. So our system is not working, not just for the people who are charged in it, it is not working for victims. And so that brings me to the role of the prosecutor and what do prosecutors need to do about this. So prosecutors often see themselves, and I think they are, guardians of justice. And so for a long time we've talked about prosecutors' roles are more than just seeking convictions, it is to seek justice. I think the problem is prosecutors for too long have focused on how do you address harm in individual cases and individual incidents, and no one is stepping back and looking at harm from a systemic level and owning it. And prosecutors, as system actors and as the guardians of justice, have a particular role that can be played in this movement to end cash bail. First, because we know that judges listen to prosecutors. Although we know they don't set bail, we know that what they say has significant impact on the decisions that judges make. We know from a study from Court Watch in Chicago that 90% of the time that prosecutors recommended release, the judge granted release. We know from studies that were done in New York that the prosecutor's recommendation was the single most influential factor in terms of what decision the judge made ultimately on bail. So not only do prosecutors play a role in sort of the everyday what's happening in court, but what we do is we work with prosecutors across the country. We encourage them, because you're a guardian and you have a role in addressing and acknowledging the harm that the system is causing on communities, you also have an obligation to help lead the fight for change. And we've seen reform-minded prosecutors take very public stances on the need to end cash bail. We see them being part of the influence in the leaders in the system because they have that role. People listen to the lead prosecutor, and that they should be using that power to help push these initiatives forward. So I'm really looking forward to engaging more in the conversation, but I think in particular prosecutors have a very important role to play.
Certainly a lot of work being done on what it means to be a reformed prosecutor
Yes.
in this country today. So I have fantastic questions from the audience. I want to start with one that picks up on several of the questions, but going back to this issue of what is the purpose of bail, right? So that therefore, because I think, Alex, I think makes a really, really important point is, traditionally public safety has been something that's considered in the pretrial process, and how do we weigh that in looking at a macro level, but recognizing people are going to deal with individual cases. So what is the role of bail in the context of public safety? In other words, is it a factor? So essentially, Alex, I think you're raising the proposition that it is and how we think about that. I think some of our experiences, at least I will say at local levels, a lot of the reform is recognizing that a lot of folks are not dangerous, and so it's not that it's an absolute around detention. But then that's also a conversation. So where do you all see that fitting in? Jay, you want to jump in first?
Yeah, I think there are a couple points to make there. The first is we should remember bail's not the only choice, and roughly 6%, I think, or so it is, of people are just held, right? Like the judge just says, you shouldn't walk the street, right? That's an option the judges have. There's something very odd about using bail as a way to keep some people in, because what it does is it says, well, I'm going to set a bail amount that I think maybe you won't make, but if you're rich enough to make it, or you have friends, or for that matter, frankly, if you're involved in organized crime and someone can draw on resources, then you can get out. But if you're innocent and poor, you can't. And there is an odd dimension to that. And as an economist, as a social scientist, I appreciate the stories that people are telling, because I think they're incredibly important to think about this issue. But for me personally, I just go to data, because that's, I guess, what I do. When you look at the data on this topic, it's hard not to think we're just doing it wrong. Right? And Dobie and Yang do some really nice work in their paper demonstrating if you wanted to keep the same amount of pre-trial crime happening, you could do so detaining dramatically fewer people. Right? We're detaining the wrong people. For that matter, if you wanted to detain the same number of people, I'm not sure why you would, but if you did, you could have a lot less crime. Right? There are ways we're just detaining the wrong people, and in part of that is because we're using a screen of wealth as opposed to different types of screens. We don't give the judges enough time. There aren't counsel at the bail hearings. There's so much randomness. And actually, on this point, I would say when you said the people we're detaining aren't a random sample, but as social scientists, we can figure that out because we have the random allocation of bail judges. And we can figure out the people that would have gotten out, knowing they commit more crimes after trial because they were detained, winds up, we find that actually that balances out the crimes they would have committed, or someone would have committed if you let more people out. And so you're not actually reducing crime by detaining more people, because you're turning people into people who will later on commit crime just by detaining them.
So I think I'd like to start from what bail is not, okay, or maybe what it was supposed to be, which was, as I said earlier, it was supposed to incentivize coming back to court, right? You post your money, you don't want to lose your money, you want your money back, so you're going to come back to court. Turns out it didn't even work for that original purpose, because we now know that that is not what impacts most people's ability to come back to court. And we have a criminal justice system, first of all, that was largely designed by and for the middle class. But in fact, in our criminal justice system, most of the people that use it are not. And so what keeps people from coming back to court is a system that assumes you can get a day off of work because you have leave. It doesn't assume that you're in a minimum or below minimum wage job, and if you come back to court, you're going to lose your job and your ability to feed your child. And so there are in order to get people back to court, we have to deal with those realities. And in terms of the purpose of bail, there are other things that we need to be doing and other initiatives that are happening across the country that are more effective even at, the original purposes, achieving the original purposes of bail. And before I pass the mic, so to speak, one of those things actually is counsel. I mean, counsel, if you are appointed counsel early in the case, you have someone there who is going to call you up and say, or who can call you up and say, you know what, we'll talk to you before you have to go back to court and remind you have to go back to court. You have someone there who understands that you don't have the amount of money that bond was set at, and can go back to the judge and can ask for lower bail based on your ability to pay. If you look at statistics with respect to counsel, a pivotal study that was done in Baltimore years back showed that if you have counsel at those early stages, you are 2.5 times more likely to be released on your own recognizance. That was in non-violent offenses, and 2.5 more times to have your bail reduced to a level that you can actually make. And recently, as part of the Department of Justice Innovations and Public Defense Project, Alameda County, which was one of 8 California counties that did not provide counsel in those initial hearings, they reversed that trend. They now are providing counsel, and in the early stages, we're seeing what used to be a 1% release rate in felony cases to a 20% release rate, and those are early returns.
Alex, did you
So
want to jump in?
the original purpose of bail is actually to get people out of jail. So the original understanding was everyone was held until trial. This is going way back. And so bail is actually a way to get out of jail. And I think we need to keep that in mind. Another thing we need to keep in mind is I actually agree with quite a bit of what Robin said, but I have a different perspective on that. And that is as follows. If we eliminate bail, so it means that we just give the judge a binary decision. Let this person out. If they can have an incentive to come back, I will release them on bail rather than detaining them. And I worry that we're going to eliminate cash bail. In fact, we're going to detain more people.
So, the question is, of course, we can eliminate cash bail, and what comes next is the question, right? And I don't think it's a binary choice. I don't think it's cash bail or you're in. We know that cash is not the incentive that makes people come back. We know that from our 12-year project in the Bronx at the Bronx Freedom Fund that showed that when we used philanthropic dollars, 95% of people came back. We know that from the bail project that's replicating the same results that's showing that people come back when we're using philanthropic dollars to pay their bail. So cash, literally all cash did was create a two-tier system of justice, as you alluded to, one for the rich and one for everybody else, so that people charged with the same crime, one could get out and one couldn't. So cash bail actually needs to be eliminated. I do think, though, when we're talking about this question of public safety, I want to add another dimension because it's one that I don't think really gets talked about nearly enough. We know what the evidence is, right? The evidence, as you alluded to, is that if you hold somebody in jail pre-trial, they're more likely to commit a crime when they get out than if they've been free all along. When we're talking about public safety and we're talking about risk and risk assessment, and we're talking in that sort of conversation around bail reform, what never makes its way into the conversation is the reality that we know the evidence is clear, that the risk to the safety of people in jail, those 2.5 million people a year or 12 million people a year or 500,000 on every single night, the risk to them is identifiable, it's proven, and it's evidence-based. It's a risk to their mental health, their physical health, their families, their communities. That risk is very high. The risk, and they are part of the public. We talk about public safety as if low-income communities and communities of color and marginalized communities are not part of the public. Their safety is deeply impacted and in fact devastated by being held in pretrial detention. And that has to make its way in. So when we're talking about risk assessments, right, we're talking about the outlier that something bad may happen over here if you release people. What you know from the data and the evidence is on this side that millions of people, generations of people, right, have had their lives destroyed, like Khalif Browder, like Sandra Bland, and like so many other names.
I want to add to the question for you, Jeremy. So for one, just to say, just to note some studies that are out there. One, Maryland judges, which is actually where I thought you were going, Alex. You went in a little bit of a different direction, but
When Maryland put limits on cash bail, they actually saw the unintended response of an increase in the number of people who were held. In other words, judges, which, the suggestion being that judges were therefore using their discretion in the absence of having bail options to actually hold more people. And so that goes back to the discretionary behavior, right? And that whether it's prosecutors or judges, that sometimes even if you eliminate certain forms of opportunity, does that have an unintended consequence? I'm not saying it does, it's just a question that's borne out by some of the experience and some of the experiments happening. So I was hoping, and also just to point to the study that says even 2 to 3 days of pretrial detention, a study out of Kentucky from 2013 showed a 40% increase in the likelihood to commit crime. Is that for our total panel? All right, see, I'm talking too much. So what I wanted to add is this context of discretion when we're thinking about the policy solutions around reform and whether or not discretion is going to continue to be a problem. So since you have a prosecutorial.
Yes. Sorry, this is so loud. I think it's kind of drawing from both, and in agreement with both Alex and Robin said earlier about how we do things, sometimes based on outliers, that this is really where we see things like what happened in Maryland have the unintended impact of resulting in more people being held. And a lot of what drives that is the fear of the head